Transfer of Property Act, Module 3. Let's see the module first. 3.1. Specific transfers under the Transfer of Property Act 1882 focuses on four key types of transfers. Lease, Section 105 to 117, Exchange, Section 118 to 121, Gift, Section 122 to 129, Actionable Claims, Section 130 to 137. 3.2. Indian Easements Act 1882. Let's start with 3.1. Leases, Section 105 to 117. A. Definition of lease. A lease of immovable property is a transfer of a right to enjoy property. Since it is a transfer to enjoy and use the property, possession is always given to the transferee. The lease of immovable property must be made for a certain period. B. Essentials of lease. It is a transfer of a right to enjoy immovable property. Such transfer is for a certain time or perpetuity. It is made for consideration which is either premium or rent or both. The transfer must be accepted by the transferee. C. Formalities involved. Lease from year to year or for a term exceeding 1 year can be made only by a registered document. If a lease is for a term below 1 year, it can be made by an oral agreement. If a lease is created by an oral agreement, it must be accompanied by delivery of possession.
D. Types of tenancy. 1. Tenancy from year to year. A. A tenancy from year to year may be made by a grant of land from year to year. B. If the tenancy is for a year to start with, but after the expiration of 1 year, the lessee continues to be in possession and pays the rent to the landlord, the tenancy is regarded as a year-to-year tenancy. C. If in case of a tenancy for a period more than a year, the landlord wants to terminate or end the lease, he has to give a 6 months notice to the lessee to quit. D. If in case of a tenancy for a period more than a year, the landlord wants to terminate or end the lease, he has to give a 6 months notice to the lessee to quit. E. In case of a tenancy from month to month, a 15 days notice to quit is necessary. 2. Tenancy at will. If the tenant stays with the consent of the landlord till such time as further period is fixed or a fresh contract is made, the tenant is called a tenant at will. The landlord will decide for what further period shall the tenancy be given. The tenancy at will does not mean that the landlord has to give a proper notice to quit. The death of the landlord or tenant determines the tenancy. That is, the tenancy comes to an end. 3. A tenancy by sufferance. If a tenant continues to be in possession after the determination of the period of the lease, without the consent of the landlord, he becomes a tenant by sufferance. This type of tenant is not regarded as a trespasser because the tenant had in his favor a valid lease to start with. No notice is necessary to such a tenant for eviction. This tenant is not responsible for rent. He is liable to pay compensation for use and occupation of the land.
E. When lease comes to an end. The lease comes to an end by lapse of time, by the happening of a special event. When a lease is granted subject to the happening of an event, it comes to an end when the event takes place. Thus, if B grants lease to A for life, it comes to an end on the death of A. Merger. A lease comes to an end when the lessee buys the property of the lessor or when the lessee takes the lessor's interest by succession. By surrender. A lease may come to an end by surrender. By forfeiture. A forfeiture occurs when there is breach of a condition in a lease contract by the lessee. Duties of the lessor. To disclose all the material facts which is known to him to the lessee. The next duty of the lessor is to put the lessee in possession of the property. Duty to let the lessee enjoy undisturbed possession or quiet possession. Duties of the lessee. Duty to pay rent on time. Use the property only for authorized purpose. Not to cause any permanent injury to the property of lessor. To disclose all the material facts which is known to him to the lessor. Not to make changes in the structure of the property without the consent of lessor. The lessee should hand over the property at the end of the lease. I. Rights of the lessee. Right to enjoy accretion in the property. To deduct the cost of expenses incurred on the repairs which was done with the consent of lessor. lessee has the right to recover any amount from the lessor which is paid on behalf of lessor, such as municipal taxes. Right to remove the fixtures he has erected during the term of the lease. The lessee may avoid the lease if property is wholly or partly destroyed by tempest, flood, or fire so as to make it impossible to continue the lease for the purpose for which it was let.
And here the difference between of lease and license.
Next, exchange. Section 118 to 112. Definition of exchange. When two persons mutually transfer the ownership of one thing for the ownership of another, neither thing or both things being money only, the transaction is called an exchange. Essentials of exchange. The person making the exchange must be competent to contract. There must be mutual consent. There is a mutual transfer of ownership, though things and interests may not be identical. Neither party must have paid money only.
Next, gift. Sections 122 to 128. A. Definition of gift. Gift is the transfer of certain existing movable or immovable property made voluntarily and without consideration by one person, called the donor, to another, called the donee, and accepted by or on behalf of the donee, and such acceptance must be made during the lifetime of the donor and while he is capable of giving. B. Essentials of gift. There must be a transfer of ownership. The subject matter of gift must be a certain existing movable or immovable property. The transfer must be made voluntarily. It must be done without consideration. There must be acceptance by or on behalf of the donee, and such acceptance must be made during the lifetime of the donor and while he is capable of giving. C. Capacity of parties. There are two parties to the gift, donor and donee. The donor must be a person competent to transfer, whereas the donee may be any person.
E. Gift is irrevocable. F. Conditional gift. G. Onerous gift. Next, actionable claims, section 130 to 137. Definition of actionable claims. Number 1. A claim to any debt other than a debt secured by mortgage of immovable property or by hypothecation of movable property or by pledge of movable property or to any beneficial interest in movable property not in the possession, either actual or constructive, of the claimant, which the civil courts recognize as affording grounds for relief,
whether such debt or beneficial interest be existent, accruing, conditional, or contingent. 2. Actionable claims are claims to unsecured debts. Examples of actionable claims. Now 3.1 Indian Easements Act 1882. 1. Introduction. Enacted in 1882. Objective: to define and regulate the law of easements in India. Easement is a right enjoyed by the owner or occupier of one piece of land to use another's land for beneficial enjoyment of his own land. Key idea: two properties must exist: dominant heritage, land that benefits; servient heritage, land over which the right is exercised.
2. Meaning and definitions, section 4. Section 4 defines easement as a right which the owner or occupier of certain land possesses as such for the beneficial enjoyment of that land, to do and continue to do something, or to prevent something being done, in or upon or in respect of certain other land not his own. Key terms and their meaning to remember. 3. Essentials of easements. 1. Two heritages. 2. Ownership. 3. Beneficial enjoyment. 4. Immovable property. 5. Right in rem. 6. Cannot be personal. 4. Characteristics of easements. Attached to land, not personal rights. Transferable with the dominant heritage. Can be permanent, temporary, continuous or discontinuous.
May be positive, right to do something, or negative, right to prevent something. 5. Types of easements and their meaning, with example.
6. Modes of acquisition of easements. Easements can be acquired by 1. Express grant. 2. Implied grant. By circumstances or necessity. 3. Necessity. 4. Prescription. 5. Customary easement. 7. Rights and liabilities. Rights of dominant owner, section 22, and
Liabilities of dominant owner. 8. Disturbance of easements, Section 33. When servient owner unlawfully interferes with enjoyment, remedies, suit for injunction or damages. 9. Extinction of easements, Sections 37 to 47. Easements terminate by 1. Release, 2. Unity of ownership, 3. Expiry, 4. Permanent change, 5. Non-use, 6. Destruction, 7. Express revocation, 10. Suspension of easements, 11. Difference easement versus license, 12. Case laws, 1. Manikayyamma versus Someshwara Rao, 2. Sundaram versus Meenakshi Ammal, 3. Nagarpalika versus Shyam Lal. 13. Summary table. Concept, sections and their key points. End of Module 3. Don't forget to subscribe. Thanks for watching.